Just before many folks took time off for the weekend, there was a big development in the case of Joe Biden's aggressive jab mandate. And Biden and his cronies aren't going to like it. I'll give you the detailed update so you can share the news. Hi everyone, I'm Gardner Goldsmith for MRC-TV. You know, MRC-TV readers and viewers likely already absorbed our first wave of information about the Fifth Circuit Federal Court of Appeals three-judge panel November 6th issuing a temporary injunction against Joe Biden's jab mask test mandate for companies of 100 or more. The temporary halt came as a response to a case called BST Holdings v. OSHA, which is a legal action brought by the Attorneys General of Texas, Utah, Mississippi, and South Carolina, as well as several private businesses, and represents just a tiny fraction of the 27 states all over the United States that have engaged in legal opposition to the Biden Labor Department OSHA command. Now, the key update. After the Labor Department's Occupational Safety and Health Administration Monday requested that the court lift its stay against this federal edict, the same three-judge panel has now denied their request and has added some very valuable commentary about the assumed medical efficacy of the mandate and its legality. On November 12th, the Office of Texas Attorney General Ken Paxton tweeted news of his success against the feds. Quote, citing Texas's compelling arguments, the Fifth Circuit has stayed OSHA's unconstitutional and illegal private business vaccine mandate. We won. Litigation will continue, but this is a massive victory for #Texas and for freedom from Biden's tyranny and lawlessness. End quote. And Breitbart's Jordan Dixon Hamilton reports, quote, in its decision, the court ordered OSHA to take no steps to implement or enforce the mandate until further court order. End quote. Which means that until the likely Biden Labor Department appeal of this ruling goes to the Supreme Court of the United States, the SCOTUS, and, well, who knows how they're going to rule, businesses right now with 100 or more workers located in the region covered by the Fifth Circuit, which includes Mississippi, Louisiana, and Texas, they will not have to engage in the government-ordered practice of telling their employees to accept an mRNA injection or get tested at their own expense and to wear masks. The jab command would have taken effect on January 4th, and the mask edict would have begun on December 5th. Because, of course, don't forget, the Biden administration is very consistent about mask wearing. They're really serious. Mask efficacy, of course, is also not disputed in any way. And as Jen Psaki's double jabbed but I got COVID anyway story tells us, the mandates and the massive fines of $136,532 per person per violation are really all about stopping the spread, and they're not about extorting people in any way. Now, curiously, this ruling comes at roughly the same time as a study from Israel showing that the efficacy of the Pfizer jab to significantly increase antibody response in COVID-19 actually decreases to near zero after 6 months. It also comes at roughly the same time as a blockbuster October 25th release from The Lancet of a large-scale Swedish study of mRNA technology showing that after 211 days, the mRNA so-called therapy provided zero antibody-induced protection. So, what practically does the mandate even do? And what government claims can we actually ever trust? That's up to you to consider. But one wonders if the judges of the Fifth Circuit Court were aware of this when they issued their new ruling, because they observed, quote, The mandate is a one-size-fits-all sledgehammer that makes hardly any attempt to account for differences in workplaces and workers that have more than a little bearing on workers' varying degrees of susceptibility to the supposedly grave danger the mandate purports to address. End quote. Well said. But you know, all of these practical questions actually are secondary to the larger issue of how the Dr. Frankensteins who command this monstrosity of a national government continue to push rabidly unconstitutional edicts via offensively unconstitutional agencies that long ago should have been questioned and eliminated from the Federal Register. While the Fifth Circuit didn't rule on the constitutionality of the Biden mandate, it did say that the OSHA attempt to impose its so-called emergency temporary standard on businesses, quote, grossly exceeded its statutory authority, end quote. Meanwhile, OSHA, the Labor Department, the FDA, the CDC, and most of the tentacles of the federal Leviathan stand as monumental insults to the U.S. Constitution, the enumerated powers therein, to the founders, and to our inherent rights. The Constitution hasn't stopped these madmen and madwomen in D.C. from creating and running such blatantly authoritarian agencies. That, my friends, is going to be up to us to do. Thank you so much for watching. Keep your eyes on this one and many others. There are other circuit court cases floating around. We'll watch them and we'll communicate with you. Please visit us anytime at MRCTV.org. That's MRCTV.org. Go to the shop, get some Christmas gifts, and support MRC TV. Check us out on Facebook. Check us out on Rumble. They don't censor us. And on Twitter and on TikTok and on Instagram. For MRC TV, I'm Gardner Goldsmith.